Well, hello there, friends, and welcome again to the Disability Law Show. Back for another week, another 30 minutes to inform you about disability law and dealing with an insurance company. It's murky business, but we got James Fireman here to clear it all up for you. I'm John Scholes, as again, James Fireman, Samfiru Tumarkin, LLP, to reach out to James and his team. You're always, willing to do so, and we tell you to do so in most circumstances. 1-855-821-5900, the phone number. Email help@disabilityrights.ca as well. We always have a main topic on the show. Usually we get that in the second segment after one break, but it'll be Guide to Disability Benefit Denials. Super important this week, so stick around for that. That's some emails, maybe a phone call or two. James, we always get going with a recent case you're working on. A week that was is what we like to call it. What do you got, pal?
I had a lady call me last week, and she was with another lawyer, still is, and she is unhappy with how things are going. She's unhappy that it's been 3 years since she came to this lawyer, and they haven't had a mediation yet. They obviously haven't resolved the case. And she's unhappy that she doesn't really know what's going on. And it is something that is almost always true when you have an unhappy client. It is almost always because you haven't communicated with them well. It's because you haven't prepared them for what is going to come during the litigation. You haven't created reasonable expectations, and you haven't updated them, or you haven't been able to deliver bad news in a timely way. All of those things are really critical as a lawyer. And so this person, there's obviously another issue here that the case has gone on for three years without a mediation. That is really, really unusual. That really should never happen in disability claims, except maybe in the most exceptional of circumstances. But if you're in this situation, if your lawyer is not communicating with you well, I'm not going to sit here and tell you fire your lawyer and come hire me. I'm going to tell you that you should go to your lawyer and tell them what you want. Tell them what you expect. And that expectation isn't about a particular result. The expectation should be communication. It should be understanding of the process and of your claim and what's happening. At a very basic level, all lawyers should be doing that effectively with their clients. And the failure to do that creates a lot of anxiety, because the people who are contacting me for help are people who, in almost all circumstances, don't have any experience with the legal process, certainly not with the disability law process. And so they have this insurance company that they're trying to deal with, this billion-dollar insurance company that isn't being reasonable with them. And they come to a lawyer because they want help. They need help in order to take on this huge behemoth. And if you're not communicating, if you're not making the process understandable for your client, then you are failing at a very basic level. So it is really critical when you are talking with your lawyer that you tell them what you expect. If they're not telling you what lies ahead, if they're not telling you when the next event is going to be, whether that is an examination or a mediation or pretrial, then ask them. And if they give you the runaround, don't accept that. Push for an answer, because you're entitled to it. You should understand what's going on. I'm not telling you that you should be difficult with your lawyer, but it is absolutely something you should reasonably expect, to have your lawyer communicate with you in a way that is going to make the process understandable.
It's funny, if anybody listening off the top, James, they might be thinking, okay, you said 3 years, super long time. So generally the process, maybe even start to finish, or maybe not quite finish. What's average, I guess, or what's reasonable?
10 to 12 months.
Wow.
When so from the date someone signs a retainer, I will tell anybody who calls me, unless it's a very unusual case, your expectation should be 10 to 12 months. And I do not like setting expectations for my clients that I cannot achieve or do better on. So I'm careful about saying that. I'm not guaranteeing that it's going to be 12 months. There are things that can happen that can make it take a little bit longer. On occasion, there are things that can make it take a lot longer, but that's really rare. And if that does happen, I'm really careful to make sure my client understands exactly why it's happening. But that is the 1 out of 100 exception. Generally speaking, for 95% or more of my clients, 10 to 12 months, we're at mediation, we get the case resolved.
Do you think this 3-year length of time you're talking about with this particular lady is maybe, I don't know, maybe this lawyer does not specify, doesn't have specific training in disability law, maybe kind of a jack of all trades? I mean, that could affect it poorly, yeah? Not knowing what they're doing?
I see that a lot with lawyers who specialize in personal injury, that dabble in disability. They are not the same. The process is very different. The expectations around what's going to happen in order to get to resolution are very different. And if you don't understand that, it's going to take longer. There's also something that I've been seeing for the last 20 years, which is lawyers will get a claim and understand that there is this 2-year limitation period and think for some reason that means that you shouldn't bring the claim until just before that limitation period expires. I don't understand it, but I see it so frequently. I used to do defense work when I started out, and you would see it all the time. You would see claims issued right at that 2-year mark. Now, there are circumstances where that might actually make sense. If there's a kind of tenuous claim, maybe yes, maybe no, you want to wait as long as you can until you have a better sense of whether or not that's going to materialize. But I've seen it in so many circumstances where there's obviously a claim from day one, and for whatever reason, the lawyer has waited until just before. Usually it's because the only organization they have is the one thing that they absolutely can't mess up on, which is a limitation date. And so they have that in their calendar, and they say, uh-oh, I have this limitation date coming up, I better issue that claim. That's the only thing that spurs some lawyers to actually start the process. That's obviously not good, needless to say. So I do see that a little bit more than you would think.
It's interesting when you say, leave it at the last minute. I've also heard, I think you've spoke about it, I think Savannah has talked about it, and Tamara on this show as well, that sometimes when it's a physical disability, if it's a teenager, someone in their youth, they may be waiting just based on growth and everything else, see if they actually do get better before they have to bother making a claim. I don't know if that's true, but... Well,
so children, minors, anyone under the age of 18 are an exception. Until you turn 18, that 2-year limitation period doesn't start running. So if you are injured in a personal injury circumstance, it's rarely going to be of any relevance when we're talking about long-term disability, because there are very few minors that would have access to a long-term disability policy. But if you are injured in a car accident or a slip and fall or what have you as a minor, the 2-year limitation period doesn't start running until you turn 18. And in some circumstances, there's good reason to wait. Maybe not necessarily till you're 18, but at least until you're sure that there's good reason to bring a lawsuit, because usually when you're talking about a minor, you're not talking about an income loss claim. So it's really just a matter of whether or not they have an injury that is going to be significantly impacting them for life, or at least for a long period of time, or require significant recovery. In those circumstances, sure, you would want to consider a claim.
Always clears it up nicely. That's why he's here. James right there. Reach out anytime. Pocket Disability Lawyer. That's another tool you can use. It's free. It's anonymous. Series of drop-down questions thinking, oh, should I apply? Should I contact James? I'm not sure what to do. Where do I start? That's a good place to start anonymously. PocketDisabilityLawyer.ca. You can use that anytime. I did mention phone calls. James and I, Tamara, Savannah, we do radio shows across the country, have done them for years. We get lots of fascinating phone calls into the radio station, depending on where we're working that particular day. And some of these phone calls are really good, and it's a learning opportunity. First phone call from one of our radio shows. We want to play that right now and talk about it a little bit. So here we go, James.
I'm on LTD. They want me to apply for disability. I don't want to, because I want to go back to work, and I'm struggling with it. I've had the papers now for about a month. They sent it to me before. I never got them, so it was a mix-up. So today I got a call from my case manager, and she told me that they're going to turn around, and they're going to slice my amount, and they're going to try to figure out what I would normally get for disability.
Talk about a CPP disability?
Yeah.
So our astute listeners might have caught that was, I'm almost 100% sure that was Lior. So I'm guessing this was a caller from the Employment Law Show. So this particular issue, though, dealing with CPP disability, we talk about this very frequently on this show and on our radio shows. CPP disability is a federal benefit that's provided if you have paid into CPP for at least 4 of the last 6 years. If you become injured and you've paid into the Canada Pension Plan for the sufficient period of time, then you're entitled to apply for CPP disability. The test for CPP disability is a severe and prolonged disability. That is almost always going to be more difficult than the LTD test, showing that you have a disability that's preventing you from being able to do your own occupation. So just because you're entitled to LTD, it doesn't guarantee you're going to get approved for CPP disability. If you are approved for CPP disability, most long-term disability policies are going to allow your insurance company to reduce your monthly payment by whatever amount you're approved for CPP disability, which is why your insurance company is going to want you to apply. And you may be thinking, well, I don't want to apply if it's just going to help them. What benefit is it to me? The answer is, if you look further in the policy, it's going to say, as is the case with this caller, if you don't apply for CPP disability, your insurance company can then, in most circumstances, estimate what you would have gotten.
And still deduct it.
Exactly.
Nice.
Take that as an offset. So if your insurance company is asking you to apply for CPP disability, you might as well. I'm not going to suggest that you should apply for CPP disability right out of the gate when you first go on medical leave, because again, it requires a severe and prolonged disability. So unless you have a disability that your treatment providers, your doctors are able to say on day one, this is something that is not going to resolve for years, you're almost certainly not going to be approved for CPP disability right away, which is why most insurance companies aren't going to ask you to apply right away. Usually it's only after you've been on disability for a year, sometimes 2 years, that they'll ask you to apply for CPP disability. But you should, even though you're not actually the one who's going to get the benefit of that CPP disability if you're approved. If you don't, it's going to cost you money. Also, if you are approved, and this is something we've talked about frequently, it puts your insurance company in a much more difficult spot. It means that it is far more difficult for them to say you don't meet the LTD test if the federal government is saying that you meet the CPP disability test, which, as I've already said, is a more difficult test to pass. And also, as you like to point out, John, if you are approved for CPP disability and your insurance company still cuts you off, you at least have that other income coming in from the CPP disability.
Is it a fairly quick process? I know it's government, but is it a fairly quick process in your...
It's about 6 months, 4 to 6 months, start to finish. So
Get on it, they tell you to.
Quick is a relative term, I suppose.
No kidding, right? All right, guide to disability benefit denials. That is coming up on the other side. That's the main topic for today, so we'll get to that after a short break right here on the Disability Law Show. Don't go anywhere. People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. Okay, welcome back. Disability Law Show. We're going to keep going here. Here's the number to reach out to James and his team anytime we're not on air here. 1-855-821-5900. Help at disabilityrights.ca. Main topic, it's a good one for this week, guide to disability benefit denials. First one, James, insurers often deny disability claims even with your doctor's approval and support. What does that mean?
Well, this is 100% of what I see. When I'm taking on a claim, I'm not going to take on any claims unless there is the support of your doctors. And so when someone contacts me, if it's a case I'm interested anyway, invariably it's going to fit this exact point here, where an insurance company has denied or terminated a benefit, even though the treating doctor has said that you still cannot work. And this happens all the time. And you may be wondering, well, how can the insurance company take the position that I can go back to work if my own doctor is saying that I can't? And the logic behind that, of course, is that the treating doctor, the GP or the specialist that is providing the primary care for your disability is going to be easily in the best position to be able to make a determination about whether you're medically fit to return to work. So how can the insurance company possibly be in a position to disagree with that? And the answer to that is they're not. They're just not. But that doesn't really matter because there's nobody looking over their shoulder when you apply and you go through the adjudication process. If they can find any reason to satisfy themselves that you are capable of returning to work, whether it is fictional or otherwise, then they'll deny your claim and they'll leave you to it. They'll suggest you can try appealing if you want, but it is not at all uncommon for an insurance company to deny or terminate benefits, even though the treating doctor has said that you cannot work. Happens all the time.
Yeah. Second one is this, James. Insurance adjusters do not have the final say. You are not required to appeal a denial, which we see all the time as well.
Yep, this really dovetails with what I was just talking about, of course.
Yep.
When the insurance company, when the claims handler, the adjuster, goes through the adjudication and they find some basis for denying your claim, even though your own treating providers or your own doctors are saying that you cannot go back to work, that is not the last word, nor do you have to go through this appeal process either. If the insurance company is saying no and your doctor is saying that you really should be on disability, you can't work, then you need to go further than that. But going further, of course, does not mean going through the appeal process. I'm not going to say what it means yet because I think I might be stepping on number 3.
That's right. Number 3 is this: you are within your rights to seek legal advice from a disability lawyer if your claim's denied. There you go.
There you go. It's like I might have seen this before.
Possibly, even written it.
It's possible. So when you're going through the process, if you are denied your benefits or if you were receiving benefits and your insurance company says we're going to stop paying you, you're going to get a letter. The letter is going to outline the reasons, in theory, it's going to outline the reasons why your insurance company has decided to terminate benefits. Oftentimes, it's pretty vague. It doesn't really give you a lot of insight into the rationale. Sometimes that's because there really isn't a good one. But in any case, once they've gone through that, there is boilerplate language that they put at the end of every denial or termination letter. And that language is about the appeal process. It'll tell you that even though we've denied your claim, we're inviting you to appeal the decision, as though this is some really generous act that they're doing, or that there is some actual chance that in going through this process, they might change their mind. And I say that tongue in cheek because think about who the insurance company is and what their objective is. They're in this to make money, and they make money by paying less benefits. They want to pay benefits as infrequently as possible, and when they are paying benefits, they want to stop as soon as they can. Once they find a justification to terminate benefits, they are not simply going to say, okay, well, your doctor wrote a really, really nice letter, even though we already had that information, so we're going to reconsider it. If you're giving them the same information on the appeal, you should not have any expectation that they're going to change their mind. Even if your doctor is saying, no, this person really is disabled, you really have to look at this, it's not going to matter. Unless the information you're providing the insurance company on the appeal is fundamentally different than what they already know. A cancer diagnosis that's just been discovered, a blood test that shows an autoimmune disease, what have you. Unless you are giving them information that is entirely unknown to them, they're not going to change their mind. And even if you are giving them information that's unknown to them, even if it's significant, doesn't mean that they're going to change their mind either.
That's where we start the legal claim, yes?
Absolutely, 100%. So if your doctors are telling you that you're not able to work or you can't go back to work if you've been off for some time, and the insurance company is saying, no, we think otherwise, there's a basis for a legal claim there. That is something that you absolutely can challenge. If your insurance company is saying no, give us a call, we'll start the legal claim.
Which I think, based on what you said in past shows, James, somebody should not be scared of, because once you start that legal claim, now it goes from the adjuster level, the elevator goes up a floor to their legal team. Now you're on people that understand the whole process, right? Now it could be, what I'm saying is it could be a good thing to get their lawyers involved because they understand what's going on here. It gets past the adjuster level, right?
It is probably the most common thing that I hear, the relief about not having to deal with the insurance company anymore, to not have to be on the front line of that battle to try and recover the benefits. Now, I'm going to stop short of saying that starting a lawsuit against your insurance company is good for your mental health.
Right.
But on the other hand, I will tell you that I have an awful lot of clients that will say exactly that. Yeah. Your personal experience may vary, but what I am saying is that the process of fighting your insurance company is going to be a whole lot easier once you have called us and we're in your corner.
And with that, we'll take a short break, get to some emails and otherwise, so stick around for that. In the meantime, that number to reach out to James and his crew, 1-855-821-5900 and help at disabilitylawyer.ca, disabilityrights.ca, pardon me. We'll get to more of the show in just a moment. Stick around. People think contractors aren't owed severance. EmploymentLawyer.ca says that is a myth. Many contractors are actually employees and are entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca. How do you force insurance companies to pay long-term disability claims?
Insurance companies deny legitimate claims all the time. They're playing the odds. They know that most people are just going to walk away.
Your insurer may ignore you, they may even ignore your doctors, but they can't ignore us.
We know how insurance companies work. We know their weaknesses. We know how to use the legal process to force them to pay you what you're owed.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you are only owed 2 weeks' pay when you lose your job. EmploymentLawyer.ca says that is a myth. You may be owed much more than 2 weeks per year. Don't settle for less. Always check with the employment lawyer first at EmploymentLawyer.ca. And welcome back, Disability Law Show. I'm John Scholes, James Fireman. Reach out anytime, Samfiru Tumarkin, LLP, by phone, 1-855-821-5900. Email is help at disabilityrights.ca. That's where we're going to go. Spencer, thank you so much in advance for writing in. Spencer James says, I've been on disability for over a year due to a herniated disc and have been following my doctor's advice. I'm considering returning to my construction job, but if it doesn't work out, will I need to reapply for those benefits?
Thankfully, no, or at least probably not. So just to answer this question Spencer has as directly as I can, insurance policies, disability policies are almost always going to have what's called a recurrence clause. And so what that means is that if you attempt to return to work after you've been on medical leave and have applied for disability benefits, let's say you're approved, you try returning to work. If you're unsuccessful within a set period of time, usually 6 months, if you're unsuccessful within that period of time, rather than having to reapply for disability benefits and then having to go through, it's usually a 3, 4, 6 month waiting period before your benefits start, the reoccurrence clause would entitle you to go right back on benefits as soon as you become disabled again, assuming that the subsequent disability is the same disability that had you go off in the first place. That's the theory behind it. And the rationale, the reason why insurance companies put this in their policies is because they want to encourage you to try going back to work. Now, that doesn't necessarily mean that because the recurrence clause is there and because you attempt to return to work and are unsuccessful and your doctor says you should go back on medical leave, that your insurance company is going to accept that. They still may not. They still may take the position that, well, you were back at work for the last month or two or whatever it was, and we say you can continue. Even though you can't, even though your doctor is saying you can't, they still may say no. So it is really important that when you are thinking about returning to work, you do so when you are optimistic that you're going to be successful, because my experience is that is the most critical factor in determining the ultimate success. And two, and probably most importantly, you have your doctor's support and approval in doing it.
Right. I want to move on to another website called mydisabilityquestions.com. It's free and anonymous. You can ask your questions there anytime. They will get answered. Maybe not appear on the show, but they'll get answered regardless. Sal this week says, after a year on disability benefits for severe depression, my insurer recommended a specific psychiatrist who is pressuring me to try a new antidepressant. My own doctor strongly advises against this medication. Can I refuse this treatment without risking my benefits? Great question.
Well, can you refuse it without risking your benefits? The answer to that, as asked, is no. If you refuse it, then you are risking your benefits, but that does not mean that you should simply do what the insurance company tells you to do. And in this particular circumstance, I would, as strongly as I can, suggest that you listen to your doctor, particularly when we're talking about medications. So if your own doctor, if your own psychiatrist is telling you, don't take this, there's a reason for that. Oftentimes, insurance companies are going to suggest measures that might temporarily make you better, might temporarily allow you to be able to get back on your feet and maybe even work for a short period of time. but that are not good for you in the intermediate or long term, or they may just disagree that it's going to be effective for you in the first place, your treating doctors. Whatever the rationale is, if your treating doctor is telling you that this is not the right medication for you, your treating doctors are when you should be listening to. Remember, they're in by far the best position to be able to make any kind of a judgment on what is going to be therapeutic for you. If your treating doctor is saying no, you should listen to them, understanding that if you don't listen to your treating doctor, there could be very significant consequences that might be far more important than whatever benefits you might be continuing for however long your insurance company decides to do it. Keep in mind, if you listen to your insurance company and start taking that medication, what's almost certainly going to happen is after a month or two, they're going to say, well, you've been taking this medication, and it's our expectation that within a month or two, it's going to start working, so you should be back at work now anyway.
Right.
There's no guarantee if you listen to them that they're going to continue paying your benefits anyway. So even though it may seem like a really difficult choice, trying to decide between whether or not to listen to them and keep getting benefits or listen to your doctor, in the end, it probably isn't going to extend your benefits by that long anyway.
Does the fact that it's the insurance company psychiatrist taint the outcome of this?
It can.
Right.
When we're talking about a psychiatrist, when we're talking about an MD, I'm a little more hesitant to just say disregard anything they say. It is my experience that although there is certainly a question of bias whenever you're talking about any medical professional hired by an insurance company, I find generally speaking, MDs, that comes up less often, but it still comes up. Mm-hmm. And so just because it is being recommended by a psychiatrist or any other doctor working for the insurance company, that does not mean by any stretch of the imagination that it's correct, especially when your own doctor is saying otherwise.
Right. Let's get, I think we have time for one more email. This one from Sophia. She writes in, says, I've been approved for LTD beyond the 2 years after finally confirming a lupus diagnosis. Despite this, my insurance frequently asks for updates, causing me anxiety attacks and increased chronic pain. What options do I have in this situation?
Well, in this situation, you're going to have to at least reasonably comply with their request for updates. But what is reasonable is an open question. Now, if the requests for updates are causing this increase in chronic pain and anxiety attacks, it is really important to put that in front of your insurance company, to put them on notice for that. Mm-hmm. So how do you do that? At first instance, it's just simply a matter of reporting that to them and saying on the record, sending them an email that says, the frequent requests for updates are really problematic for me. Okay. This is causing an increase in my anxiety and my pain. It is also important to make sure you're talking to your doctor about that, to make sure that you update your doctor on your condition and tell them the reason why you are having this exacerbation, why the calls from your insurance company are causing these lupus attacks or causing the anxiety and the chronic pain. Get that in the medical records and then put that in front of your insurance company. Is that going to change their behavior? It might. It might if someone gets that and understands what they're doing, but at the very least it puts them on notice. And if it doesn't change their behavior, and if it does lead to a more significant condition where your symptoms are flaring up more frequently, where it's becoming more problematic for you, now the insurance company is opening themselves up to a possible claim for damages, particularly if they ever decide to cut off your benefits. So it is really important, even if there isn't ultimately anything you can do to change the behavior, to put that information in front of them, to document it medically, and make sure that you put yourself in the best position going forward.
Now, Sophia has been approved beyond 2 years. That's a good sign, no?
For sure. Once you're beyond that 2-year mark, that change of definition, it means the insurance company has accepted that your condition is disabling you from any occupation. And that makes it much more difficult for them to down the road say that you're no longer entitled. But that doesn't necessarily mean that they're not going to still want frequent updates. And there are particular adjusters that are just going to ask for it more often than they ought to.
All right, good stuff, my friend. Amazing again this week. James, thank you so much, and we'll wrap it for another week. You can always reach out in between by phone to James and his team. 1-855-821-5900 is the number. help@disabilityrights.ca is the email address. Thank you for watching. We'll give it a week, and we'll join us back here again on the Disability Law Show.